All right. Well, it's 12 o'clock and we've got a lot of information to cover today. So I think I do want to get started on time. I want to take a quick second to thank everyone for attending today's program. I'm Vicki Rivkin. I'm the Outreach and Education Legal Liaison with Shalva. Today's program has been approved for MCLE by the MCLE for 1.25 hours of professional responsibility credit for attorneys. Unfortunately, we're not authorized to issue CEU credits at this time. I know that's a question that comes up a lot. For those of you who are joining us for the first time, I'd like to introduce you to Shalva. Shalva's mission is to offer deep Jewish cultural competency and expertise in domestic abuse to support our diverse community. There's a lot more information about Shalva on our website, shalvacares.org, which I'll put in the chat, and also in the course materials at the end. Throughout the program, we may use both she and he as pronouns when discussing survivors and perpetrators. While the survivors in the vast majority of reported cases of domestic abuse identify as female, we recognize that males and non-binary individuals also experience domestic abuse. Sadly, many of these cases are not reported. I also want to take a moment to acknowledge that if you're triggered by anything in today's program, please reach out to your mental health professional or call our office at 773-583-4673. This program is being recorded, and I will send out the recording after today, so you don't have to miss out on anything if you feel you do need to step away. So with that, I am going to turn the moderation of today's program over to Rebecca Berlin-Meltzer, who is the head of Shalva's legal committee.
Hi, everybody. I'm the head of Shalva's legal committee and also on the executive board, and I am just so proud to be part of this organization. And I'm super excited to moderate this really informative seminar today. We have two literally amazing speakers. You couldn't have come to a better lunch meeting. The first speaker is Judge Grace Dickler. I have known her my entire career, and she is such a mentor to me and so many others who I know are on this seminar. Judge Dickler graduated from Northwestern University School of Law, and she was in private practice for a bit before she became a judge. She was a judge for 39 years. She started in 1982 as an administrative law judge. She then became a federal immigration judge. And those of us who practice in family law were lucky enough that she was assigned to the Domestic Relations Division in 1991. She practiced there for a lengthy period of time, first in Skokie. And then in 2010, we also had the honor of having her be the presiding judge of domestic relations, first Domestic Violence Division, and then in 2011, the Domestic Relations Division. She shepherded the division through many changes, including 2020 and COVID, and kept our division open and made sure that families were protected and helped by ensuring access to courts when many other people didn't have access to courts immediately. Sadly, in 2022, she left the bench, but we were very thrilled that then she opened a mediation practice through JAMS. And I can tell you from personal experience, she is not only was a phenomenal judge, but is an even better mediator. So her expertise today is just unparalleled from a judicial perspective. She also volunteers her time immensely, not only today in educating others, but she's been the past president of the Jewish Judges Association. She serves on the ISBA Family Law Section Council and does tons of volunteer work with her synagogue and many other organizations. If there's an award that is to be had, she's had it. Whether or not it be the American Academy of Matrimonial Lawyers Samuel Berger Award or many other awards, she's just up for it. So I'm really thrilled to be able to hear from her and learn from her and be able to have everybody else hear from her. Our other speaker is just as much of a rock star. Despite my lack of history with Adam, I have every time I've met him, and I'm sure you will today, be beyond impressed with his expertise and his understanding and his combination of the law and tech abuse. And so he has a really interesting background that I hope that you will see through his presentation. So Adam's a lawyer. He got his Juris Doctorate, and he also has a Bachelor of Arts. He has been on so many committees and advisory roles. He is on the Coalition Against Stalkerware. He has been on a White House task force about online abuse and harassment. And he's in the World Economic Forum and the Digital Justice Advisory Committee member. just the words that I'm saying clearly tells you that he has this expertise in online abuse and tech-enabled abuse. In 2019, he created and was the CEO and founder of NTAB. It's End Tech-Enabled Abuse. So you'll hear from him about how technology impacts our world, and especially how it's used in abusive situations. This organization is a social impact organization that provides professional development, training, and resources to empower organizations and professionals to address technology enabled abuse. And if he's done a speech, it's on everything. I mean, the list goes on the topics that he's an expert on. And so I'm really proud to have him here. He also was the legal technology director of Laura's House. It's a domestic violence agency nonprofit in California. And so beyond that, he's also a frequent lecturer. He writes for the New York Times. I mean, he's in it to win it, to really educate and minimize tech-enabled abuse and make sure people are informed. And so with that, I think Adam's going to take it from the beginning. If you have any questions, please pop them in the seminar. You're welcome. You'll be texting or messaging just us as hosts, and we'll bring them up, and we can go from there.
Wow, best intro I've ever gotten in my life. Thank you so much. That was so nice. Well, I'm going to take the first leg of this presentation, and then Judge Dickler is going to take the second half. Your Honor, did you want to add anything before I get started?
No, I did not. Go ahead.
Okay. All right, great. Well, hi, everybody. I'm going to try to keep this to a tight 30 minutes or less. I have way too many slides to do this, but I'm going to move through a lot of, I think, relevant topics to our work, or when our work intersects with domestic violence. And if our work is intersecting with domestic violence, then I think due to the ubiquity of tech-enabled abuse, it's also intersecting with technology. I don't think they are mutually, it's just not possible that they're mutually exclusive when you're dealing with patterns of domestic violence today in the digital age. And that makes sense, right? Because in today's world, technology is required to survive and thrive. It's not really optional to jettison technology from our lives. I'm sort of embarrassed to say that typically the first thing I do when I open my eyes in the morning is I check my phone, and I'm sure that's true for a lot of us. And it's one of the last things I do at the end of the day. And in my waking hours, I'm usually on a screen or working or doing something. So it makes sense that, if we're relying on it, certainly someone who is fleeing an abusive relationship or is in an abusive relationship really needs safe access to technology in order to, escape or find shelter or connect with their support network, or, a variety of different things. But that reliance on technology, we really need to be mindful of the fact, I think, that victims are harmed where they are, and where they are more than any time in human history is online and on their devices. The average person has 80 apps on their phone and 90 online accounts. So that's 170 different ways for somebody seeking to harm a victim to exert power and control over them, to monitor their communications, to monitor their location, to steal money, to impersonate them, to intimidate them, to gaslight them, to do things that existed before the internet, but the reach is much broader today. The order of magnitude of harm is often greater when domestic violence goes digital, because our technology goes with us wherever we go. And so if we aren't digitally safe, then we're not safe anywhere. And being able to navigate this with victims and survivors today is really critically important. But the good news is, and I am the poster person for this, is you do not have to be a tech expert to act when a victim is being harmed online or via their technology. I'm a lawyer. I think historically we are not considered a tech savvy bunch. That's obviously, there are plenty of tech savvy lawyers out there, but I am not somebody who worked in Silicon Valley or have a computer science degree or worked in the field of technology. But what I am is somebody who deeply cares about preventing and addressing gender-based violence. And if you care about that, then you have to be able to prioritize the digital safety of victims with the same level of intention as we do their physical safety. And today I'm going to be talking about some very practical ways that we can do that and to verify allegations of tech facilitated abuse and things of that nature. There's really three reasons when we're talking about domestic violence that we don't have to be tech experts to get involved or be confident in navigating a tech facilitated abusive situation. Number one, there's a personal connection here. It's not some random hacker online or some anonymous person online that is harming the victim. In fact, it's somebody that is known to them, right? Which is important. That's what I'm going to get into a little bit later. It's really important that when we're trying to keep them safe or verify these allegations of tech facilitated domestic violence, knowing who the person is and knowing things about that person who is engaging in abusive behavior through technology can really serve us as we navigate these waters. Number two, no hacking or tech skills required, just opportunity. An example of this that I often give is I worked on this case where the victim said, hey, that my ex hacked my Amazon account. And hacking, by the way, is a term of art that I don't like to use because in domestic violence, it's seldom hacking, and hackers would be offended by people calling what happens in DV cases hacking. But what happened was the ex she used to use his laptop to shop on Amazon. And when they separated, she never updated her password. And because she used to use his laptop, Amazon considered it to be a safe device. So he was able to log in, just entered her password popped up automatically. He logged in, he could see her new address and learn things, see what she was shopping for and things like that. Which is a gross violation of privacy, but not hacking. Like, let's be honest, it's not hacking. And in the age of AI, technology has put really sophisticated tools in the hands of the unsophisticated. An example of this is our deepfakes. So deepfakes are a form of essentially video editing and face swapping, where you can upload a photo of somebody to a deepfake site, and it will, using AI, take that person's face and swap it onto somebody else's face in a video. And when you press play, now it looks like the person from the photo is the individual in the video. Now, most commonly, the way this is being weaponized is through inserting people into pornographic videos without their consent. So this is how easy this, when I say you don't need tech skills, this is how easy it is. So this is an example of a deepfake pornography app. So the person uploads a picture up here on the upper left of Emma Watson and selects a pornographic video below her. And literally they select Emma Watson's face with their finger, drag it over the person in the video and release. And in the third pane, you can see now it looks like Emma Watson's in that video. And if you press play, it looks like Emma Watson is engaging in sex acts. So sharing intimate images and videos without consent is nothing new to domestic violence fact patterns. But now it used to require that the intimate image or video in question existed. Well, now people can manufacture this, right? You don't need, so it changes the risk assessment because now anybody is a potential victim. And it shows you, this is, by the way, this doesn't work on men, it only works on women. So it really is violence against women technology. And it's point and click, right? It literally is just using your finger. So we couldn't be making it easier for folks. And then finally, they have or had the victim's trust, and that gives them access to passwords and personal information and the devices and accounts and apps that they use and passwords and password reset questions, which, by the way, we should never answer honestly. If you're required to reset a password and it says the questions are, what street did you grow up on? And what was your mother's maiden name? I can find that information out, but certainly a current or former partner has access to that information. There's a question in the Q&A that I'll answer live. Why does it only work on women? Well, because there's the people that are creating this technology are men. The people who are consuming this content and creating this content are primarily men. So they are paying for it. They are driving almost all of the traffic to these sites, and which drives ad revenue and sale of their personal information and things like that. And so it can absolutely, it's driven by that. And so the reason it only works on men is because you have to train these models to do something, right? This is artificial. And sorry, I will start speaking a little slower because I know we have our interpreters here today. And so you have to train these models to do something. Hey, I'm going to teach you how to do something. Well, they're only training these models on the bodies of women. And so they are not giving these models even an opportunity to, understand what a man's body looks like. And so that's why. And this is true with undressing apps and a bunch of different apps. So the attacks can appear very sophisticated and technical, but the reality is they're not. They're almost always, an unsophisticated attack that was made possible by this personal connection and access to the victim. I can't tell you how many. Well, I could. It's more than 10, let's say, cases that I've come across where a victim goes into a confidential address program, and then their new confidential address is located because they order food through DoorDash, or they get a ride share through Lyft, and their ex-partner still has access to that. So very not very sophisticated, right? But we have these large digital footprints, 80 apps, 90 online accounts, that creates this opportunity. And historically, we don't prioritize our digital safety as meaningfully as we do our digital safety, but that needs to change, I believe. So let's talk a little bit about how tech-enabled abuse shows up in domestic violence cases. So a very common one is accessing accounts and devices without consent. A lot of people will say this person hacked me. And again, with all the device and password and account sharing that goes on in relationships, it's very rarely hacking. It's just they have the opportunity, as I explained earlier. And I stay away from the term hacking because that's a term of art that can mean different things to different people. And we don't want this getting lost in the translation. We don't want a victim or a survivor going to law enforcement and say, this person hacked me, and the law enforcement officer thinking, well, I don't think this person has those skills, and they discount the allegation. Where what we want to say is, hey, my ex got into my Instagram or and was reading my emails on Gmail because we used to share a device at home together, and I never updated the passwords after I fled the abusive relationship. There's no chance for miscommunication there. So one of the ways, and when I'm done speaking, I'm going to share these links in the chat so you'll be able to access them. But if you've never gone, if I'm working on a case and the victim says, this person knows where I am all the time, they're reading my emails, I get excited, not that this is happening, but excited by my ability to do something about it, because we can absolutely take measures to verify whether that allegation is true and then do something about it by helping the victim stay safe. So if you're a Google user, which most of us are, we have Gmail, Google Maps, use Chrome to surf the internet. If you've never been to myactivity.google.com, it's worth checking out, because if I'm the bad actor and I have access to my partner's Gmail account or Google account, I can go here and log in. And right away, there's two things that are very violating that I can learn about my partner. One, I can see every website they visit and every page on said website that they have gone to. So immediately, I've got eyes on their web activity and I know what they're searching for and looking for. And secondly, I can see their location. So if they're using Google Maps is, for the most part, unless you've got the privacy settings adjusted, which most folks don't, is set to track us even when we're not using the app, so that it can learn our patterns and be helpful and suggest addresses and directions when we start to look for something. And so what Google's done in the effort of being convenient has actually, what I will often say is, okay, yeah, this is really convenient for me to see these things, but convenience always comes at a cost. So if I'm in here, it's so convenient that there's just a list of what this person has searched for, what websites they've gone to, what they've used their maps for, all chronologically listed here. So it is and this is something, a private investigator would have trouble providing with such detail. And we can do it by simply logging in to Google, which is a problem. So if I was working with somebody and they say they're reading my emails or they know where I am, and they use Google for their email, for example, then I'm immediately going to this website. If you've never been to myaccount.google.com, and I should say, the exercise I'm about to go through with y'all works on any platform, works on Instagram, works on Apple, works everywhere. Okay, so I would go here and say, okay, let's see if somebody is in fact snooping on you. And I would log into this account with the victim. I would tap security on the left-hand side, and then I would scroll down to see what devices are actively logged into the victim's account. And if they say, okay, well, yeah, this is my MacBook right here, but I don't have an iPhone. My ex has an iPhone, but I don't have an iPhone. Then I would either click the device or click manage devices. And it'll give me a little more detail. Oh, this iPhone logged in 47 minutes ago. And here's a little more details button. Let's click that. Now I can see the model of the phone that was logged in, what browser they're using. I might be able to get their IP address. And I know when they first signed in, which, surprise, surprise, was shortly after the relationship started. So all of a sudden, not only can we verify whether this allegation is true, but we can learn something about the person doing it. And because in domestic violence, it's not a stranger, but somebody who we know is accessing the device, the fact that if they have a model iPhone X, let's say, then if a model iPhone X is logging in and the person, let's say it's a restraining order or ex-partner, also has that phone, that's likely not coincidental. And when we're talking about the preponderance of the evidence standard, that's really helpful evidence. So we can take screenshots of this, and then you can tap don't recognize this device and kick them out. So we've verified the allegation, we've learned something about the person engaging in this behavior, and then we've removed them from the account. And then you'd want to update the password. Really pretty straightforward. You don't have to be a tech expert to do that, to provide a lot of value, right? And you can do this with all accounts, you can, as I mentioned. And so we should, this is what I mean by prioritizing digital and physical safety equally. We would want to, we would want to know if someone's in our home, and we should know if somebody's in our accounts, right? Like these are, but one is less obvious than the other, right? And so, and because we weren't raised to prioritize our digital safety or born with digital instincts, because our safety instincts really work in the physical world, they're not designed for virtual environments, they need to be learned, right? And that's part of what we do at NTAB, is try to sort of upskill folks to address this stuff. If somebody is reporting that they are being tracked without their knowledge or consent, then there's sort of a different approach that we want to take, which is it's seldom some tracker or GPS tracker or something like that. When we're talking about domestic violence and people who are commingling their phones and their accounts and things like that, I'm instantly thinking about inside threats, right? Because I've worked on many cases where a victim is concerned or has been alerted that their ex-partner is monitoring their location or is tracking them. And what you want to do is it's really a process of elimination, because we have these digital footprints, and the reality is most of the apps on our devices track our location, right? And so what we want to do is start moving through a process of elimination, right? How might this person be tracking the victim? You use Lyft. Okay, let's log into Lyft. Let's see if anybody else is currently logged in. If they aren't, great. Let's update the password and move on to the next app, because that's not how they're tracking you. If they are logged, somebody else is logged in, then that could be the source of the problem. Or food delivery apps like DoorDash or Uber Eats and things like that could be used to track somebody. Google Maps, Waze, these things do a really good job of tracking our location. So you want to make sure no one's logged in there either. Right? Parking apps. I'm starting to see more and more parking apps show up. in cases of tech facilitated domestic violence, because these people track where they're parking, and it can give somebody their location. Social media, right? Snap maps traps your location in real time. Device tracking, turning the device itself into a tracking device by saying, I lost my phone, and being able to easily zero in on where the victim is. Accessing accounts without consent, which we talked about earlier, would allow me to see your calendar, see your messages, see your emails, see what you're doing in your accounts. That would give me insight into your location. And then finally, there are many other Starbucks apps and different things like that. But you really want to encourage the victim to go through, see who's logged in. And by the way, if you don't know how to check the login activity on Instagram, just Google it. You don't have to be a techie to do this. I don't include every step in these presentations because they're changing all the time. So just do a quick internet search and it'll tell you how to verify it. It's very easy to do. One thing that is challenging is app connected vehicles. So you don't get a lot of alerts when someone's tracking you through your car. And because there's a lot of car sharing that happens in domestic violence cases, if the victim's trying to enter shelter, let's say, and the car has an app that they may or may not know about, that car could be unsafe, right? And cause victims to have to choose between their safety and their mobility. And this is the future, right? All new cars essentially have apps now, and that allows people to unlock them, locate them, turn the alarms on, do a variety of different things. So if a victim is concerned, so this is a little more challenging because the victim doesn't have control may not have control over the app connected to their car. And it's very opaque to try to figure out what's going on here. So one thing that we can do is you can go to vehicleprivacyreport.com. Okay, so this is a site run by a nonprofit called Privacy for Cars. And if you enter the vehicle's VIN number at this website, and again, I'll put all this in the chat when I'm done speaking. Whoops. What you get is a report that tells you, okay, yeah, your car collects your identity, your location, your user data, doesn't track your fingerprint or your Face ID. It sells to affiliates. It may sell to insurance brokers, which they can use to identify whether you're a good or a bad driver, and then adjust your insurance rates without your consent or knowledge. And you can see that there are certain apps connected to your car. So this is super helpful for somebody. I think this is super helpful in general, but it's also really helpful for somebody who is concerned that their car has been weaponized against them. So once you determine, okay, yes, my car is app connected and does send this information, it has telematics is the industry term for it. Then what we suggest people do is go try to figure out what car app is associated with the vehicle and attempt to download it and open an account. If the victim is unable to open an account, that means somebody else has the account, and that means the car is potentially unsafe. If they cannot open an account, then great. You can't have two account holders, right? So that's good news. But in the former situation, if they find that somebody else, likely their partner, has an account with the app, then there's a couple options. You can try to reach out to the automaker to let them know what's going on, but I can tell you right now, they're not going to get involved. I'm working on legislation, federal and state in California around this. So what really the victim has to do is make an informed choice between safety and mobility, right? And make and assess risk for themselves, maybe look for alternative transportation, and then wait for legislation. The legislation that I'm co-sponsoring and working on would basically require automakers to remove the abusive party's access if the victim is granted exclusive use of the vehicle in a restraining order, temporary or restraining order after hearing, or was granted the car in a divorce settlement agreement or judgment or something like that. So but most people don't even know that their car has an app because they don't use the car's app, right? Unless it's a Tesla, you're not starting the car with the app. And I will share, it says, somebody wrote, can you share the website for my business? Yeah, I will happily put that in the chat. And then can you put it in an order the other party must turn over the login information? I think so, right? Like these are things that now that we know, and we're going to get, I think, we're going to get into this later, but yeah, what kind of things can we include? What kind of language can we include in agreements now that we know? Because these things typically happen in the shadows, right? But if we shine a light on it, then we can also pull it in within the four corners of an agreement or an order requiring the person to disable the account and transfer it to the survivor, which would be amazing, right? Which would be amazing. So I'm going to stop there because I want to make sure, and we'll have more time for questions, but I'm going to go ahead and stop there to allow Judge Dickler to have plenty of time to deliver her presentation as well. So I hope that was helpful. I'll include my contact information, website, and these resources for y'all so that in case you have questions that don't get answered today, I can answer them for you later. Okay, so let me, Your Honor, I'm going to make you, let's see, the host.
No, hey, Adam, make me the host.
Okay. There we go. Okay.
All right.
Okay. Hello, everyone.
Give me a second. I just want to share my screen. Here we go. There you go.
So, hello, everyone. I almost feel like I should tender my time to Adam because he really is amazing, isn't he? So, as you've heard from Adam, the world is definitely getting scarier and scarier, particularly for women. And yes, sometimes men and non-binary people who have had the misfortune to catch the eye of abusive or malevolent individuals who wish to do them harm. And unfortunately, the capacity for inflicting harm does increase as technology increases. So this self-professed Luddite will try to discuss two areas that will hopefully help you and will help you help your clients. First, how to capture and preserve evidence, and second, how to present that evidence to the court. Slide 2, please. Slide 2, as you can see, it's me with a different hairdo. But anyway, I have nothing more to say about me, but I would like to say a few things about others before we get started. First, Barbara Moore, a 3L at UIC, who took out time during her finals, no less, to help me research and prepare this presentation. Many of you will be seeing Barbara around soon as she has been offered a position at Schiller, DeCanto, and Fleck. And I'd also like to thank Barbara Muchin, who allowed Barbara to help me instead of tending to her duties as a clerk there. I also want to acknowledge my fellow panelists, Adam, who you've heard from and is fabulous, and Rebecca, who is so committed to the issue of domestic violence for their work, not only on this presentation, but on keeping survivors safe. And of course, Vicki Rifkin and Allison Annixter and the rest of the committed Shalva family for all their hard work to battle the plague of domestic violence. Since I first became aware of this organization decades ago, I have watched with admiration its growth, competence, and compassion. So I'm really delighted to be here. Okay, I'm going to stop rambling and get down to business. Slide 3, please. So on this screen, you see a variety of items, and you may be getting nervous. Don't be. Authentication and moving preserved documents into evidence is what we will be discussing. Everything ranging from text messages, voicemails, emails, telephone calls, media such as Instagram, Facebook, now Meta, Twitter, now X. Slide 4, please. Although it seems overwhelming, every type of electronic evidence is basically the same in how it is treated for evidentiary purposes. Laying a foundation and authenticating is very similar for everything you try to introduce. Text message screenshots, social media screenshots, and most other screenshots are treated the same as any other document in terms of authentication. So as we talk about in each item, keep in mind the rules are the same for all. Slide 5, please. Now, I'm going to just briefly talk about this. I'm not going to go into great detail because, as Adam pointed out, Google is the greatest resource of all. But I am going to talk a little bit. So on an iPhone, text messages, simultaneously press the on-off button and the volume up button. Androids do differ. However, you should be able to take screenshots on most Android devices by holding down the power and volume down buttons. Some devices also have a screenshot button in the pull down menu, which really makes it easy. Again, when in doubt, ask Google. If more than one screenshot or photo is necessary, though, to establish continuity, include the very last message from the prior screenshot in the new screenshot. With computers on a Mac, Shift Command 3. That's how you take the screenshot. But be careful. Once you take a screenshot on a map, by default, it goes to your desktop. So please caution your clients about this if the abuser still has access or may see the computer. This automatic default location may be changed in the screenshot app. On a Windows laptop, press the Windows key and the print screen key together. Windows will save your screenshot in your picture/screenshots folder, not on your screen, not on your desktop. For safety's sake, I would recommend trial runs on innocuous texts and emails. If for some reason your client is unable to take a screenshot, you or a family member or a friend should take a picture on a separate device. Next slide, please. Slide 6. So obviously, none of what we just talked about will be worthwhile if the phone is lost, the spouse destroys it, it is stolen, the computer crashes and data cannot be retrieved, etc., etc. So the preservation of the data is crucial. How do we do this? The easiest way is for the client to forward emails to the attorney or a trusted friend. Likewise, with texts, also, the client should invest for an insignificant monthly cost in a photo saving application such as Dropbox, OneDrive, Google Photos. That will save all photos to the cloud, and they will be there no matter what happens to your photo or computer. You can obtain information from your cell providers as to when texts and phone calls came into and out of your phone, their duration, and the number they came from. However, the length of time this information is retained varies widely from provider to provider. There is conflicting information on the internet as to the length of time that data is retained by the specific carrier, sometimes ranging from as much as 3 months to 10 years. It's very confusing and unclear. What is clear, however, is that the content of the text, what the text actually says, is kept for a very short period of time, usually a few days. So my advice is to tell your client to contact their provider immediately as soon as they realize that they wish to retain some of the information. Of course, to obtain information from the abuser's phone, you must obtain a subpoena from the court, and the abuser will be aware that this is occurring. If your client has the means, you can send the device to an e-discovery advisory firm. The e-discovery specialist will address the identification, collection, processing, reviewing, and analyzing and producing the evidence. Just Google e-discovery firms and look at their reviews or ask your colleagues for referrals. You will then have all the information you need at your fingertips. Slide 7, please. Remember, documents that include screenshots of text messages are treated like other documents for purposes of evidence. Next screen, please. People v. Cronick. This is a case that is cited frequently relative to text messages. The appellate court noted that an adequate foundation for admission of documentary evidence is laid when a document is identified and authenticated. To authenticate a document, evidence must be presented to demonstrate that the document is what the proponent claims. Factors that a court uses to authenticate writings similarly apply to email messages. The court in Cronick did not find the court in Cronick did not find any Illinois cases that addressed text messages. Thus, the court looked at a North Dakota case. The issue in the North Dakota case was that although the phone records indicated that the texts were between the defendant and the complaining witness, the defendant claimed that there was no way to establish who actually sent the messages and whether they were accurately transcribed. The court found that there was sufficient evidence from the complaining witness, the circumstances, and his knowledge of the defendant's cell number and the signature on the text messages to authenticate the testimony about the text messages received and the picture that he took of the text messages. In Cronick, the document introduced into evidence purported to be a transcription created by the school principal that recounted the message as read to him by the complaining witness, a student at the high school. Despite the fact that some words on the transcript were changed via the word processor spell check feature, the court held that the authentication requirement was met by virtue of the circumstantial evidence. The circumstantial evidence presented included records from the phone company indicating that the state's text message transcripts contained the accurate date and time each text message was sent from the defendant to the victim, and the victim's testimony as to the context of the messages, the accuracy of which was acknowledged in part by the defendant. Next slide, please. In contrast, see People v. Watkins, where the admission of text messages for a limited purpose was reversed on appeal. In that case, the state wanted to show that the defendant used a cell phone found in a drawer where drugs were also found by the police. And what the police wanted to do was to help prove a constructive drug possession case. The only evidence offered to authenticate the text messages by the state was that the phone was found in the same house as defendant, in a drawer in a common area, and the fact that some of the messages referred to or were directed at a person named Charles, which was the defendant's name. The court held that there were missing items important to authentication of the messages. There were no cell phone records to show the phone belonged to or was used by the defendant. No identifying marks on the phone or the screen to indicate a connection to the defendant, other than the references to Charles in the text. The fact that the investigating officer testified that photos taken of the phone screen were true and accurate depictions of the text messages did not change the court's opinion. The officer had no personal knowledge of the text messages and had no idea who was the owner or user of the cell phone. Slide 10, please. What if a person is calling over and over, or is under an order already not to call, or calls in a menacing manner and denies ever calling? It is important to immediately take a screenshot of the incoming phone call and a screenshot of the phone log. And if your client still has a landline, of the caller ID. Also, even if it is not the one belonging to the abuser, it is relevant if it is one that he or she frequently or always calls from. Caller ID can serve as corroborative evidence. Next slide, please. People v. Caffey. The caller ID issue was addressed in People v. Caffey by the Illinois State Supreme Court. This is a very gruesome case, which I'm not going to go into the details, but you should read it if you are able. By the way, all of the citations to all the cases I have included in materials which will be available to you. In this case, the court held that the information displayed on a caller ID device is not hearsay because there is no out-of-court asserter. The caller ID display is based on computer-generated information and not simply the repetition of prior recorded human input or observation. for the omission of caller ID evidence is that the caller ID device be proven reliable. This may be done by testimony that phone calls from this number have previously been received and that it is the same individual. Nothing fancy is required. Remember, in Illinois, it is illegal to record a phone call without the party's consent. So taking a screenshot is probably the best you can do, unless someone else is there to listen and you have the caller on a speaker. I looked up whether in a situation where threats are being made, it is still illegal to record a conversation, and I was able to find any exceptions. Seems unfair, doesn't it? And unsafe, and maybe it's something that should be pursued by the DV community. I suspect it already has, but I really was not able to find anything further on that. Slides 12 and 13, please. So we're going to talk about now People v. Tedder. In this case, SK, a 16-year-old, went on a dating site claiming to be 18, and she met a 21-year-old. They started a consensual sexual relationship that started to go sour when she discovered that he was still in communication with an old girlfriend. About 3 months into the relationship, SK left him a voicemail wherein she referred to herself as a, quote, stupid 16-year-old. Ultimately, SK ran away from home, became pregnant, her mother got involved, the police got involved, and Mr. Tedder was arrested and charged. Central to the case was the issue of whether defendant and SK engaged in sexual intercourse after he knew she was 16 years old. Defendant voluntarily gave his cell phone to the detective, who turned it over to the U.S. Secret Service Electronic Crimes Division, who downloaded it to a thumb drive and provided the evidence to the detective. The court admitted the thumb drive into evidence, and the voicemail was played for the jury during cross, wherein SK referred to herself as a stupid 16-year-old. Defendant objected. The court allowed. The appellate court affirmed, stating a foundation for audio recording can be established through witness testimony. In this case, SK identified her voice and stated she left the voicemail on defendant's phone in February 2013. Providing an adequate foundation, even though the person that actually loaded the message, the quote, silent witness from the phone onto the thumb drive, was not in court. Slide 14, downloading emails. Now, at the beginning of the presentation, I warned you that I was a Luddite. Consequently, rather than explaining how to do this to you, I am going to direct you to Kurt the Cyber Guy on YouTube. I watched it. He is really clear and has a number of videos on many topics, including this one, that you will find very informative. Let's go to the next slide, please. Emails. I have a personal email and a business email. My business email, which is on Outlook, retains deleted emails forever. My personal email does not. Once I trash an email, it stays a few days and then it's gone forever. So it is important to save documents. As noted before, Screenshots or recordings of emails are the best way to preserve evidence. Please include the header information because that will include the IP address, which will be crucial in determining ultimately the source of the email. Authentication of an email will be the same as with text messages and other forms of telecommunication that we used. As mentioned, under the admissions of text, emails are treated the same way. And if emails are coming from a fake email address, using one's IP address and the content of the email will help the court determine the authentication of the email and the sender. Tracking an IP address can be simple, but it really is too complicated to describe under the time constraints of this. And again, everything is better by Google. So I suggest that either you try to Google that information or contact an IT expert to guide you on that. Next slide, please. Social media. It is imperative to tell your survivors that some social media apps notify the other party when a screenshot is taken. In my research, the only apps that have these notifications are Snapchat and other apps that have a vanish mode. This means that the message or photo, when viewed, immediately disappear, leaving no record in the chat history. With regard to evidentiary matters, other evidentiary treatises and legal authorities recognize various traditional methods for authenticating electronic communications, such as email messages, text messages, and social media contents. These methods include the reply doctrine, distinctive characteristics, chain of custody, or other processes ensuring the accuracy of the message and the identity of the sender. Illinois law has long acknowledged these principles, including authentication through circumstantial evidence, such as appearance, contents, and substance. Appellate courts have upheld admission of electronic and social media communication when authentication factors are satisfied. For example, in cases like People v. Kent, the courts considered factors like the sender admitting authorship, unique information known only to the sender, or circumstantial evidence connecting the messages to the defendant. Similarly, in cases like People versus Curry, where Facebook messages were at issue, the courts examined the totality of the circumstances to determine whether the messages were properly authenticated. As long as there is sufficient circumstantial evidence connecting the message to the alleged sender, courts have upheld their admission into evidence. Next slide. I was going to talk about, sorry, I actually already discussed this one, so let's go to the next one. I was going to talk about GPS tracking, but Adam discussed it much more in detail than I could have, so I will not talk about this at this time. Go to the next slide. With deep fakes, Adam also discussed this. So the only thing that I'm going to say about deep fakes is that, in fact, Illinois does have a new law, and the new law took effect January 1st, 2024. And this new law piggybacks on the revenge porn law that was previously enacted. And so it is now against the law to do a sexual deep fake. And I wanted to briefly discuss a case that you all, I'm sure, are familiar with, what that hit the news recently, which was a high school in McHenry County, which is dealing with photos of reportedly about 30 students and 3 teachers that were altered by AI. And the school district is collaborating with investigators to hold the perpetrator accountable. Although to my knowledge, no arrest or charges have yet been made, except sadly, it's been announced that the suspect is reportedly a student at the school. And, sadly, what a way to ruin your life and the lives of others when it's just beginning. So in closing, we have concentrated, or I have, on how to bring matters in front of a judge. But really what is crucial is to keep survivors safe. So please remember that in Illinois, we have a cyber stalking criminal law that is a class 4 felony that carries an incarceration penalty of 1 to 3 years. And the law criminalizes everything from threatening to share nude photos, to making threats on social media, to harassing text messages, to monitoring the location of the victim, and so forth. So don't forget that there are criminal penalties available also. And Legal Aid Online is an invaluable tool for obtaining information. So look up everything that's available to you, become acquainted, and then that way you'll have a total arsenal that you and your client can use. Thank you, and stay safe.
Thank you, everybody. This was really informative. I don't know if we have any other questions for any of the speakers, Judge Dickler or Adam. I think we have one in the chat. It says, isn't it permissible to record a call if you believe a crime is being committed and any threats or abuse are a crime?
Sorry, I researched it, and I'm sorry I didn't find that, and I asked some folks and I didn't find that either. If I missed it, I apologize, but that wasn't what I came up with. But
Yeah,
if
no,
you
I
know
didn't.
more,
I don't know more either, Judge Dickler. And beyond recording, we have a question about having hidden recordings in a home. My experience with that has been, it depends on if it's recording audio or video or both. So certainly, at least in Illinois, to be careful where it's a 2-party consent state to video or audio recording, including whether or not you've disclosed that and the recording is by agreement. Adam, I don't know, circling back with what Judge Dickler, thank you for doing the slides. If you have any other final thoughts about ways to protect victims, or candidly, even just ourselves. I think this was super knowledgeable for people to realize how much information is available online, and just to really talk about our digital safety, even when not in a threatening position, just to make sure we're being mindful of that in how we operate in our daily digital world.
Yeah, I mean, it's very much mindset driven, I think, and starting to sort of expand the way we think about, our well-being and safety, and sort of also expand the way we think about crime. And that there's not like I tend to not say cyber stalking or online harassment. It's just stalking, right? It happens, or bullying. All these things tend to happen. If they're happening, they tend to be happening online and offline. And so really rethinking the way we sort of approach this to sort of expand the scope. And I did see something in the chat about, is there anything the community should be thinking about in regards to AI? I'll just add that this is becoming more and more of a challenge to our work. And, with respect to deep fakes and undressing apps and the manipulation of photo and video, primarily to harm women and girls online by sexualizing them without their consent. It's amazing that y'all have laws in Illinois to address this. But it's also important that we remember that, if it's some anonymous person online, it can be challenging to hold them accountable in the criminal legal system. And there are things that we can do to support victims who may not want to pursue legal action. They can, for example, de-index if a video, authentic or synthetic, by the way, is being hosted on a certain website, you can ask Google to remove that website from its search results, period, end of story, so that if somebody searches the victim by name, that web page will not come up. So there are things that we can do for folks, and really sort of just being very knowledgeable about those things so that we can react with confidence if someone's being harmed by synthetic images, which is happening more and more. I'm seeing it all over the country, especially in middle schools and high schools and colleges.
I think we have, and I want to point out Nicole Spicer, an amazing attorney, commented, I'll put in the section of the statute that there may be an exemption for recording. So I'll put that there. And we also had a question, I believe this is probably from an attorney, about, can we require, I'm not sure if we answered that fully, like sharing of contact information or log information in an order to force a turnover. I certainly think we not only should force a turnover, but maybe we have language about not accessing the other person's information, right? We can, in divorces, certainly require people to be refrained from accessing their online information. And that way, then if you do find it out through the ways that Adam and Judge Dickler have directed us to learn about, then we could file a petition for rule and have consequences when you find out that there's some tracking or other inappropriate behavior going on, whether or not you need to do that as a temporary restraining order initially to stop behavior, or just even in the beginning of case, being mindful that there may be abuse when you're meeting with victims, and understanding the type of case that you're bringing into and having the conversations with the other side about what behavior is appropriate or not.
I would think, Rebecca, that it can also be put in orders of protection as well.
Certainly. Certainly, it's a good point. And I think that, when you find someone tracking in one way, it's probably not the only way. You may not have found the other ways in which there are tracking, but if you find one way, there's probably others. And so being mindful of that and asking for it to stop is important.
And in fact, I think that the order of protection language was just amended recently legislatively to include electronic
tracking.
Yes.
Yeah. Any other questions before we end? I think this was such an informative seminar, really gave us really action items, and we have everyone's contact information put in the chat.
I'm going to try and put the survey link up on the screen, but given my capabilities today, it may or may not happen. So I'm going to go to window. Oh, nope.
I'll put it also, I think, the survey.
Wait. No. Oh my gosh. Wait, here, let me do this entire screen. Let me see if this works. I am going to
While you're
share.
doing that, we had a question about CLE available. I think there is continuing legal education for attorneys.
Yes.
Not
Yes.
if you need some other legal education. If you filled out the form to come to register, we have your contact information, and Vicki or someone else from Shava will make sure we get back to you with your CLE. We certainly appreciate you attending, and hope that you continue to attend Shava events and learn more about us on our website.
Great. I give up for today.
Okay, we'll send contact information as well. It was in the chat, the Survey Monkey. And then we hope, with any information, feel free to reach out to any of us.
Great. Adam, thank you for your help.
Yes, thank you all.
Likewise, Your Honor. Thank you. This was really fun. And thanks everybody for hosting this. It was so great.
Thank you.
Thank you. Take care, everyone. Bye-bye.
Bye.